Good morning, members. We have passed the appointed hour. We have a quorum. The meeting is now called to order. First, according to House rules, we have to elect the chairman of the subcommittee. Nomination, please. One member nominates, seconded by another member, and the nominated member should also accept that nomination. Mr. Wu Chiu, I nominate Ms. Sit Ho. Any seconder? Mr. Kenneth Chen seconds, and Ms. Sit Ho accepts the nomination. Any other nomination, please? We don't have enough members to support a second nomination. Now we need to follow the formality. Somebody has to ask whether I accept the nomination, because Mr. Wu has the highest ranking in the president's list. Mr. Wu, please take the chair. Any other nominations, please? No. So I declare Ms. Sit Ho the chairman of the subcommittee. Welcome. Thank you very much. Do we need a vice chairman? No? Okay. This is a negative vetting of an order, and therefore we are subject to a deadline. Let me spell out the milestones first. This is an order subject to negative vetting. Even if we extend the deadline, and the notice for extension to the House is the 8th of November, and then approved on the 13th of November by the full Council. Today is the 29th of October. I think we need to extend the deadline. If members want to move any amendment without any extension, the deadline for notice is 6th of November. If there is an extension, deadline is 27th of November. The country park order caused a lot of controversies in the last term. The question was whether the Council had the power to amend the order. That was a constitutional issue. Before we make any decision, I would like to get the officials in, and then I'll let the legal advisor to explain to members the basis for our power to amend the country park order. Before the officials come in, I want to ask members whether you prefer the following dates. The first one is Tuesday, the 5th of November, 2013, 4:30 to 6:30 p.m., and also Wednesday, 6th of November, 9 a.m. to 10:45. Shall we mark these, reserve these slots? Okay, we have The one on the 6th of November, 9 to 6. I beg pardon, 9 to 10:45 a.m. As for meeting with deputations, I think I'll ask members later. After the legal advisor has briefed members on the issue, then I will let members decide whether you think the constitutional issue has been resolved and whether we are going to meet the deputations, and also about the consultation of the district councils. We also need some information to decide on how wide the scope of the consultation should be. Thanks for coming. If I may introduce the government officials attending our meeting, and they are Mr. Joseph Sum, Assistant Director, AFCD, Ms. Elvis Au, Assistant Director, AEPD, Dr. Leung Siu Fai, Deputy Director of AFC, Ms. Cindy Yao, Senior Assistant Law Officer, Department of Justice, Ms. Lonnie Ng, Senior Government Counsel, Department of Justice, and Mr. Leung Chi Hong, Senior Country Parks Officer, AFCD. I'll ask the legal advisor to update us on the background first. Thank you, Madam Chairman. Just now, when the chairman made reference to a similar order, in fact, under the order made under Section 14 of the Country Park Ordinance, that was in respect of the Comprehensive Amendment Order 2010, designated Consolidation Order 2010. We set up a subcommittee. The 2010 order was in respect of the Clearwater Bay proposed map to replace the original map.
So a simple way to put it is to designate certain area within the Clearwater Bay Country Park as the landfill, and in the course of doing that, there was a problem, and that was whether this council, in relation to the 2010 order, would be empowered to amend it, including repealing it. On this particular issue, the administration and the legal services unit of this council did not see eye to eye with each other, and in simple terms, the LSU's view is that under Section 14 of the Country Parks Ordinance, with regard to the designation of country parks, the chief executive must, in accordance with the CE in Council's required practice, to designate such country parks, and there is no room for maneuvering, because under Cap 1, that is the Interpretation and General Clauses Ordinance, Section 34, Subclause 2, any amendment will have to be in line with the power under that particular ordinance. And given the fact that the chief executive in council has to gazette the plan, there is no power for this council to amend it. So the inference is that this council does not have any power to amend it, including repealing it. But then the LSU's view is different. It's of the view that yes, under the decision made by the CE in Council, the Council is not allowed to designate other areas as country park. So the plan, as approved by the CE in Council, will have to be gazetted as it was. But then it doesn't necessarily mean that this Council does not have the power to amend this plan, including repealing the amendment order. In the end, the subcommittee agree with the interpretation by the LSU, and as a result, the chairman of the subcommittee at the time also proposed on behalf of the subcommittee to repeal the amendment order. The proposed amendment, which the president ruled to be in order, and he also agreed to include that resolution in the agenda, in the council meeting agenda, and as a result it was also passed by the LegCo at its meeting. So the subcommittee therefore was able to repeal the Amendment Order 2010. So that's the background to this case. All right, any questions from members? So in relation to the background brief by our legal advisor, administration, do you have anything to add? No? Okay. I've asked the secretary to take out several papers from the last term to circulate to members, and the first one is the subcommittee on subsidiary legislation with regard to the expansion of the Cheung Kwan O Country Park, and a copy will be distributed to members. And also with regard to the LSU's report, is about the repealing of that amendment order, and as a result a subcommittee was set up to look at the decision-making process and also the constitutional issues. So a very detailed report was also submitted, so that would also be circulated to members for your reference. Before I invite the AFCD and the EPD to move on to the substance of the order, I'll ask the DFJ's representative to tell us more about the government's position. Has there been any change at all from the last term? Yes, Madam Chair, concerning the amendment or otherwise of this order, our position is the same as ours. Is the same as that in 2010, as the legal advisor just said. Section 34, under Cap 1's power, with regard to amendment, it should be commensurate with the power to pass that. And if this council doesn't have the power to amend it, then it naturally means that this council also does not have the power to repeal it. But then in the wake of the repealing of that amendment order by this council in 2010, the administration did not appeal against our decision. So there was no further amendment order being tabled before this council. Now let's move on to this new order. That's the Country Parks Designation Consolidation Amendment Order 2013. Mr. Wu Chi Wai, all right, we had a similar resolution last time, and there was no appeal from the administration. But then, according to the DFJ, its stance remained the same. So, if on this occasion we are going to repeal it again, so does that mean that they're going to seek a judicial review in the light of the latest developments? Yes, there would then be a constitutional crisis, because last time, if you park illegally, even if you were not charged, it doesn't mean that every time you park illegally you will not be charged. And of course, it's our view that the administration has violated or broken the rules, but then we haven't been able to argue it before a court. Alright, on this occasion we are looking at the plan of the country park. So let's look at it first. Mr. Au. Thank you. Yes, with regard to the amendment order and also our proposal, please take a look. Well, with regard to the designation order, the purpose is to designate or include some country park enclaves into the Kamshan, Tai Long, Sai Wan, and Yuen Tun country parks. As you might recall, in June 2010, there were illegal digging activities going on in these areas, and as a result, that gave rise to some concerns. That's why at a joint panel meeting in 2010, there was a discussion, and in the light of public concerns over the issue in 2010, and in the 2010-2011 policy address, the administration undertook to either include the enclaves into country parks, including Kamshan, Tai Long, Sai Wan, and so on, or determine their proper uses through statutory planning to meet conservation and social development needs. And in accordance with the pledge made by the administration and its policy in 2010, after consulting the country parks or Country and Marine Parks Authority or board, we came up with some principles in designating country parks. In accordance with the set of principles, we assess the three areas, including Sai Wan, Kamshan, and Yuen Tun, and we believe that they should be better protected by including them into country parks. And as a result, in December, between October and December 2012, we allowed the plans to be inspected by the public, and during the 60-day period, we received comments. Some were against, some were in favor, and some 3,200 emails were in support of that, but then there were 9 objections. And in Para 6, we have set out the major views put forward by the objectors, and our response can also be found in Annex B. In accordance with Section 11 of the Country Parks Ordinance, on the 7th and 8th of February 2013, with regard to these objections, meetings were held by the CMPB to listen to those objections, and after a careful deliberation by the board, it was unanimously agreed that all the objections would be rejected, and on the 12th of April 2013, the Secretary formally notified the objectors of its decision, setting out the reasons and so on, and the CE in Council on the 7th of May 2013 approved the draft maps of the 3 country parks, and the designation order is made under Section 14 of the CPO, and the plans have also been gazetted, and the CE has designated these areas as mentioned above, and on the 11th we have gazetted, and on the 16th it was tabled before this council, and then the commencement date would be the 30th of December this year. And in making the designation order, the AFCD and the authority have also consulted the local residents and also the Sai Kung District Council, And in triggering this statutory process, in fact, 1 year beforehand, the AFCD already consulted the Rule Committee and also the Heung Yi Kok, and under the law and also the statutory procedures, objections were received. And the background to this is that in August 2010, actually, the matter was also discussed at the TPB with regard to the drafting of plans and so on. Some comments were also received, and there were views in support of including the area in the Sai Kung Country Park. So that's my presentation. Thank you. As we have many new members this term, we'd like the administration to tell us more about what happened in Sai Wan last time, so that members would be aware of the administration stance and how we dealt with the incident on the last occasion, because there was extensive digging, and since it was not part of the country park, so under what statutory procedures did you manage to stop that from happening? So I think members need to know that. Yes, Madam Chair, I'll briefly say a few words, and then I'll ask the AFCD to supplement. Well, in the 2010 incident, it was found that in Sai Wan, there was some private land and government land being extensively dug, and in accordance with the then statutory procedures, including the CPO, and also the land registration, and also the anti-pollution legislation, we enforced the law accordingly, and it also involved government land. For the rest and also the details, I'll defer to the AFCD. So what actions were taken by the AFCD then? Well, at the time, because it involved not just private land, but also government land, and the departments concerned, including the AFCD and the Lands Department, acted in accordance with the legislation under their purview to mount a joint enforcement operation, and subsequently the administration was able to prosecute some of the individuals involved under the relevant legislation, and they were also convicted. So can you refer us to the relevant legislation, because in terms of the digging up of the land within private sites, it would be highly controversial if you moved in to prosecute them. So can you give us more details? Well, in the end, when we managed to prosecute some of the individuals, well, most of them are actually contractors, as they have violated the bylaw of country parks. That is, without getting permission, they transported some construction machinery into the private site, and as a result, we were able to prosecute them. Because if you know the topography there, well, the private sites were located near the beach, but then the beach itself is also part of the country park, and as they moved in some construction machinery there without permission, we managed to prosecute them, so they only broke this bylaw.
Any questions from members? Mr. Wu Chi-wai. Yes, I want to ask about the law. In fact, we are discussing the dumping of construction waste, and if that is piling of construction waste on private land with the if this is with the approval of the owner, nothing can be done about it. At present, you can only rely on the moving of construction machinery. But if they use bare hands or they use hammers, then would that be okay with them? Say it is farmland. Now, the land is still not within the country park. The law that can govern the enclave is subject is the lease. If it is ordinary digging or digging of a pool, that is permitted use. But we have to consider whether the actual construction will affect the streams, will affect ecology, and will cause pollution. These are the factors we have to consider. Basically, we look at what is permitted within the lease. Mr. Chen Chi-chun, now, they breached the law because they passed through the country park, they moved the large-scale material, large pieces of construction materials through the country park. But if they just break up the large materials in pieces and then put them in, or they drop it through a helicopter, then can you sue them? Mr. Ao or Mr. Leung? The land doesn't belong to the country park. As said by Mr. Chen, if they use a helicopter to parachute the construction equipment onto the land, if they don't pass through the country park on land, say by using vehicles, then that is not in breach of the country park ordinance. The provisions are very simple. The provisions cannot tell you much. They just say a certain map with a certain number. I just want to know if you have any projections of the maps, like these large maps. We can, of course, read these large maps, but the best arrangement is that you can have a PowerPoint to show us what is the scope of the map. Do you have the information in hand? We can provide this to members after the meeting. We can display the maps at the next meeting. Instead of reading a big map, stretching out a big piece of map in front of us, we better have the PowerPoints. Any further questions? Yes. Concerning the last controversy, what is the mechanism for incorporating the enclaves into the country parks? Or should it be incorporated into village development under the town planning ordinance? I hope that the administration can provide more specific information. Say we take these three enclaves as an example, Kam San, Yuen Tun, and Tai Long. And there are also Hoi Ha and Solopun and Pak Lap, which under the arrangements of the town planning board. What are their differences? Why you go through two different channels for these two different batches of enclaves? Yes, perhaps you can explain to us how you come to the decision to designate these three enclaves as part of the country park. Before you draw up the draft map, what procedures were taken? Were there any objections? And then what was the gazetted process? Yes, Ms. Ao. Now, since the statement made at the policy address, we went before the Country and Marine Parks Board, and then review the principles for designating country parks. Apart from considering conservation and recreation matters, we should also consider the aesthetic aspect, and we should also consider private land as well. In May 2010, the principles or criteria were agreed by the Country Marine Parks Board, and that includes value, say conservation value, recreation value, aesthetic value. The fourth factor is whether it's in harmony with the country park. And we also take into account existing scale of development and potential pressure. In deciding what sites should be included into country parks and what sites should be included in OEZPs, we look at the recreation value, conservation value, aesthetic value, and its harmony with the country park. And these three are in line with the criteria. They have high conservation value, aesthetic value, and recreation value. And they are adjacent to the country parks. These three enclaves, if you are not told, you would have thought that it is part of the country park. As for the areas that are put under the OEZPs, with regard to the scale of development and the relation with the neighboring development, they are more they're more suitable to be grouped under the OEZP. We assess the sites according to these criteria, and then we submit it to the CPMB, and then with the agreement, then we can have the drafts, we can go to the EXCO, and then we can consult the public. As for conservation value in Saiwan, you can see that aesthetically it's closely related to country park. It is also welcomed by the hikers. It is the top of the 10 most scenic spots in Hong Kong. It's the first of the 10 most scenic spots in Hong Kong. So the value is indisputable. So you can see that in terms of aesthetic value, in terms of conservation value, and in terms of relation with the country park, it is of very high value. And in Kam San and Yuen Tun, their government land in Saiwan, about 24% belongs to private land. Mr. Kenneth Chen, good morning. As said by Mr. Wu, we need to look at the matter from a policy perspective. The official referred to the 2010 policy address, which stated that the administration would look into the dealing of enclaves within the country park. Some could be incorporated in the country park, some could be dealt with through the town planning ordinance. The issue cannot be dodged. We are not dealing with Park Lap, Solopun, or Hoi Ha. In discussion of the matter, members may compare these three sites with the other three sites I mentioned. Now, the order involves three enclaves. Now, in discussing the matter at the CPMB, it seemed that most of the attention was focused on Saiwan. But what about the two other enclaves? Were there strong views for or against the designation? Probably not. So we could focus our attention on Saiwan. There were several objections. Yes, basically in Saiwan. Other two enclaves were not controversial. You're correct. Okay. Now, concerning the authorities' representation in respect of the private land, the administration says that the rights on land, on private land, will not be affected. In particular, the construction of exempted houses. Can this argument stand in terms of the law? One bone of contention is that with the inclusion of the enclave into the country park, the right for building exempted houses will be taken away, but according to the authorities' representation, the rights for NTEH development will not be taken away. I want an answer from the official. Yes, let me explain that. I want to stress several major points. Now, we incorporate private land and government land into country park. Only in Taiwan, there is private land, 24%, about 4.8 hectares. As for incorporation of land into country parks, it's not government resumption of land. It's not resumption of land. Somebody mistaken that that as land resumption. Now, in fact, incorporation in country park will not resume private land. Now, it is in the country park. There is a difference. The AFCD will play a supervisory role, and your development has to get the approval of the AFCD. Even if the land is not in the country park, if there is a site for development, the AFCD will be consulted by the by the lands department. In fact, there are private sites in country parks, 460 hectares altogether. And among the private land, on the private land in country park, there are NTEHs. So there is no conflict. It is not either or. Even if it is a country park, there can be small houses, NTEH. In the past, there were applications for NTEH, and they were approved. The authority and the board scrutinized the application, and there were approvals given for building small houses. To allay concerns, we can make a further step. With consultation of the authority and the CPMB, there is a set of guidelines published in our representation concerning the enclaves, which will be incorporated in the country park. There will be a note in the map. If there is an application, it will be considered by the authority, and will try to be sympathetic and reasonable in handling such application. But there must be an application put before the authority. The note is a further step to make the process more transparent. Let's try to avoid the sensitive spots. You can find a suitable site to build a village small house. I hope I can address the question. In fact, we want to discuss it in the open and exchange views. It is in the paper, and members do read papers, but we want to spell it out in front of the public. So there is no question of land resumption. You've taken away my land. You have to find a replacement for that. The private owner still owns that piece of land.
Next, on the paper that you just referred to, you refer to certain policies and measures, and for the enclaves in country parks, you also have this note on how they are going to be used. Well, this is a very lengthy footnote, but then what's the meaning of this? Because you said that it's just an internal guideline for the authority to consider his policies and measures. So is it just a guideline, or is it or does it have a more powerful position so that we can all refer to it? So what's the status of this note? Well, yes, it's a note to this paper, but then as we explained, the authority, after taking into account the objections made, and there was some anxieties and concerns, and as a result, the authority submitted the note to the CMPB for deliberation, and after the CMPB's deliberation, it was felt that the set of guidelines and notes should be disclosed for public's information, and we did submit it to the SciComm Rule Committee, and it was also uploaded onto the webpage of the AFCD, and the AFCD and the authority, of course, would also refer to that. So maybe I can also defer to the AFCD to explain a bit further about this footnote. Well, it's not just an internal document. In fact, it's also a public document, because the footnote has also been uploaded onto the webpage of the AFCD. And as Mr. Au just explained, in a process of consultation, the Sai Kung District Council set up a working group to look at the inclusion of Sai Wan in the country park. And in the process, in response to the task group's comments, well, they said that some villagers were concerned that once their private sites were included as part of the country park, then if they want to build small houses, or if they want to undertake some minor works, then what would the department or the authority do in vetting such applications? And they had some anxieties about this. And in the light of their concerns, the department and the CMPB prepare this very detailed notes, and the content says that in terms of the application procedures, these have been set up very clearly. And also, in relation to their concerns whether the development of small houses would be affected, we would set out the assessment criteria, and some basic criteria have been set up in the notes, including the location for the proposed small house, what's the topography, and whether or not streams and rivers will be affected, and the surrounding ecology will be affected, whether trees have to be felled, whether that can also be avoided. And on the whole, whether the ecology, the habitat, and also biodiversity would be adversely affected, and whether the facilities within the country parks, in particular some tourism facilities like trails, will be affected. And in accordance with the criteria, we would conduct an assessment, and when necessary, the CMPP would also be consulted for its comments, and such comments will also be forwarded to the relevant authority, because according to the procedure, they will have to apply through the Lands Department, and then the Lands Department will also have to consult our views, and then our views will be passed on to the Lands Department, and then the final decision will be notified to the applicant. So in terms of the procedures and also the vetting or assessment criteria have all been set out in the explanatory note. And as I just said, the explanatory note is available on our website, and members can download that or browse that on our site. Well, a brief or short follow-up. Alright, under the explanatory note, according to what you know, have there been any processing of applications in accordance with the footnote or explanatory note? Has there been any case? No. So are you already processing in accordance with those explanatory notes and so on? Well, as I said, there are 460 hectares of country parks located within private sites, and if they want to apply for the construction of small houses in accordance with the explanatory note, we will process those applications. In fact, these are nothing new. In fact, in accordance, we already had this set of criteria in processing the applications. On this occasion, we're just trying to translate that into this explanatory note, so that everybody will have a better idea as to the criteria based on which we are processing these applications. Yes, Gary Chen first, but then before you ask questions, well, there are some new members joining us. I'd like to remind you that if there is any direct or indirect pecuniary interest, please do declare your interest before you speak. Are there any landowners here? All right, Mr. Gary Chen. Thank you, Madam Chair. Well, this subject often attracts two camps of views, and earlier on I also noticed in the press that some people have filed for judicial review and they have this rule committee or village background, and you said that we adopt this negative vetting procedure and it's not problematic. But then recently I've also heard people say that in fact some of them might apply for injunctions. I don't know what the substance is. Well, maybe they will look at the amendment order or the designation order, and if they indeed take action, then in the course of scrutinizing this amendment order, what will there be problems or obstacles? So I'm mostly concerned about this. Legal advisor. Thank you, Madam Chair. In fact, in relation to this order, well, it's made under Cap 1, Interpretation and General Clauses Ordinance, so it's gazetted and approved under that, and the purpose of this subcommittee is to scrutinize this subsidiary legislation, and in determining whether or not, in accordance with Section 34 of Cap 1, whether we need to move any amendments is up to us to decide, and the whole process is in line with Article 73 of the Basic Law, which empowers this Council to scrutinize any legislation that is tabled before this Council. So this is a statutory procedure, and we believe that this procedure, when it's carried out in tandem with other procedures of this legislature, would not be in conflict. And of course, it's for members of the subcommittee to consider, assuming that, as Mr. Gary Chen just said, well, there might be cases before the court, and there might be certain practices, or there might be orders by the court. Then is it appropriate for us to continue with the scrutiny while there are court proceedings underway? Well, yes, that's for members to consider. But then, basically, as a matter of principle, there should be no conflict between what is being done in this council and what is being done in the court. Madam Chair, I'd like to know if this council has received any legal requests by the villagers other than the JL petitions. Have we received anything like that? No. All right, then we can just proceed with the scrutiny. In fact, I'd also like to put this to the administration. I'd like to seek the views of the DFJ here. All right, on the JL case, my understanding is that they have already filed for that, but then what's the scope of that? Because last time when we attended the House Committee, we were told that you had no idea whatsoever, and the Deputy Chair also told us that it's not an injunction either. That's why it's not a problem at all. So I'd like to know exactly if you know the scope of that JL, and in your view, would there be any conflict with the scrutiny of the amendment order by this subcommittee? Of course, you think it's okay, or else you would not have come to this meeting. So, but can you tell us more about this? Well, I'm not from the litigation unit, but then I'll be telling you whatever I know. Well, we received this JL application, and the crux of the matter is that is to review the Sea in Council decision to approve or amend that plan. So it's about the decision by the Sea in Council to amend that plan, and I think they are still applying to the court for leave for the filing of a judicial review. With regard to what's happening in the court at this stage, the administration has yet to receive any order from the court as to whether there is an injunction to be issued by the court. That's why I agree with the legal advisor's comment. That is, there is no conflict whatsoever, and we can proceed with our procedures of scrutinizing this amendment order. Thank you. Yes, legal advisor. Yes, thank you, Madam Chair, for bringing up the issue, and I'm also grateful to the DFJ's colleague for her advice. I'd like to highlight one more point. In fact, upon the receipt of some letters from the Hang Kok, for example, well, it involves certain issues. Even if they are of the view that our procedures can be carried out in tandem with the judiciary's procedures, There is one point, however, that I'd like members to understand. That is under the Rules of Procedure 41.2, it says that members or the chairman or the president would not refer or should not refer to any case which might be prejudicial to the court proceedings. So this will apply to all the proceedings of committees, panels, and so on. So it's about the rules applicable in court proceedings. Well, there are 2 points here, Madam Chair. So in the course of our deliberation of the amendment order, will there be certain remarks which might be prejudicial to the courts making a ruling on certain cases? I think that would be based upon the bone of contention that is presented in court. And factually speaking, well, what we know is very little about what's going on in court. We received a letter from the Hang Yi Kok, and earlier on at the House Committee, a reference was made by the fact that there's a letter from a lawyer, and just recently the DFJ also told us about the latest development, and what we know about the case before the court has been rather obscure. And as chair of the subcommittee, in accordance with Rules of Procedure 41.2, in due course might need to make a ruling. For example, certain remarks or certain discussions, if they might be prejudicial to the court case, then the chair might need to make a ruling. But then we will have to have a better idea as to what the crux of the matter is before the court, before we can tell. Okay, so after the court has granted leave for the case to be listed for this judicial review, and then after we have learned more about the details of the case, then we will be able to make a decision. But that in the past, within this council, there were many meetings, and the administration would say that as there's a judicial review underway, is not able to answer any issues relating to policies. But then many veteran lawmakers already said that if you just talk about the policy without touching on the details, it would not affect the JR case in court. And of course, in this case, we haven't yet heard about the details of the case, and the legal advisor will also be assisting us, and he'll keep an eye on what's going on in court, and he'll remind members in the course of their remarks whether or not they might be prejudicial to the court case in question as provided for under the Rules of Procedure. So when members discuss too much about the case, or if their comments might have affected the court proceedings, and then the chair would be empowered to do something about it. But then would the chair then have the power to ban any member from making any comments at all? Well, for any member to be the chair of the subcommittee, he or she will have to act very cautiously. Yes, the chair here might have some discretionary powers, but then that can only be made under very careful consideration. So please be assured, I would not be expanding my powers without any restriction, and I would not be narrowing your ability to speak at all. Yes, Mr. Wuchiwai, thank you. Because in the enclave there are 24 hectares of land under private ownership.
If the administration can provide us with the information. Say there are specifications as to whether it's building land or agricultural land or village land. I don't know whether there is any such categorization and the nature of such private land. in the past, there were successful cases in which small houses were allowed to be built. Was it on private land, and was it specified in the lease that the land was for building houses, or there is no need for such provisions? Now, if there is any change of land use, then under the town planning ordinance, approval procedures have to apply. And will there be any land premium involved? Now, there is the issue of buying up of anti-small house rights, and therefore, they can use these rights for building small houses to say build small houses within the enclave with a large development. Now, 24%, only 4.6%, or rather 4.6 hectares are private land, not 24 hectares, 4.6 hectares only. The majority are agricultural land, some are building land. As for village small houses, concerning the application for small houses in the enclaves, most of these enclaves are not covered by OEZPs. So there is no land use specification as to whether the piece of land is for commercial or for residential development. The control is only subject to the land lease. It depends on the lease conditions. Say the lease condition may spell out agriculture use, or may spell out is for building houses. It depends on the lease of that particular lot. Even if it is farmland or building land, construction of village small houses have to get the approval of the lands department. You mean approval? You say approval. Now, for areas under OEZP, if there is any change in land use, one has to go through the planning process as well as to pay a premium. Is there need to pay land premium in order to change land use? Mr. Chairman, according to understanding, the District Lands Office will deal with that under established procedure. For village small houses, they follow the established procedure of NTEH. And if you need information, we can ask the Lands Department to provide information. I hope they will give me the information. And we don't have representatives from the Lands Department, no. Okay, please provide the supplementary information in writing. Mr. Chan Hang-pan. Now, concerning the Saiwan incident, now you prosecuted the contractors for moving machinery into the country park. But point is not clearly made. If they dig with bare hands, can that be permitted? And if the site is included into the country park, then any digging will not be permitted. Even if you approve them, they still need to move machines into the site, onto the site. Say if there is a piece of land which is not in the country park, what sort of rights will be deprived of if that site is not is included in the country park? And what acts on that piece of land that can be done would not be permitted after the inclusion in the country park? Yes, I think you need to supplement it with a written document. I don't mind a supplementary document. Concerning the rejection the compensation mechanism is mentioned. Can you also provide information to us with regard to the compensation mechanism? Concerning regulation, the AFCD will speak on that. And we will provide the details afterwards in writing. Now, concerning the difference, there is a difference. With the inclusion into the country park, there is another level of supervision, and the inclusion is for that purpose. It is supervision according to the country parks ordinance. If a development is not compatible with the country park, then the authority can reject the application or the authority can take action. There is a difference. But is there any big difference in reality? As far as NTEH is concerned, there is no big difference. At present, the District Lands Office does consult the AFCD even if the site is not in the country park. In the future, the AFCD will have a formal role in supervising the land use. In the note, we have already spelled out the criteria. There is no conflict. Anyways, an application has to be made. As for the difference, there is that is in respect of management. For enclaves, they are not within the country park. The AFCD cannot manage the enclaves. We cannot go in and improve the environment. But when it is included in the country park, it becomes part of the country park, and the AFCD has the power to manage that site and also improve that site. As I said in the paper, recreation facilities can be provided. Just like the other parts of the country park, you say that you can see that they are well managed and in order because they are looked after by the AFCD. If there is any large-scale development, then the Country Park Authority has a role to play. Any development that is not compatible with the country park will not be allowed. If it is included in the country park, even if it's private land, you can go in and make improvements. Yes, if it is private land, then we have a policy. It was implemented in 2011. We encourage the owner to work with the NGOs to apply for funds from the ECF and make improvements to enhance the conservation value of the private land. We have funds earmarked for that purpose. We cannot go in to do anything, but if it is government land, we can do that. Say for Saiwan, 76% of the land belong to the government. Therefore, the AFCD can go in and make improvements. As for private land, we've talked to the villages. The administration is willing to help them to apply for a partnership scheme to manage the site and improve the site. In fact, in the Saiwan incident, the administration said that they could develop ecotourism, and the administration was willing to talk to the landowners. I think the officials should update us on that negotiation. Now, some say that their private property is infringed because they cannot conduct any development, and they have no money to maintain the place, and they cannot sell the place. So in terms of conservation and development, what is the progress? Mr. Chung, Christopher Chung. The District Council has strong objections towards the development, towards the inclusion, rather. the District Council's strong reaction against the inclusion. Is it really necessary to include that into the country park? It's still the top 10, even if it's not included. Without your supervision, is still very good. So, will you still work with the villages, cooperative villages, to conserve the place? Is it so dangerous? I cannot see that in the paper. It seems that you try to ram it through, although you own the majority of the area, but part of it is still private land. Why you include that into the country park? It seems that you try to confiscate the land. Is the situation very bad? Can you have some sort of middle-of-the-road arrangement?
主席，就區議會回應嗰個意見方面呢，其實我哋喺文件都講。
As for the response to the District Council, we've consulted the District Council, we've listened to them very carefully. And they have set up a task force, and we attended 3 meetings of task force. At one meeting, the chairman and 2 members of the CPMB attended the meeting to communicate, to talk to them. We understand their view. We try to address their concerns, and we are talking to the departments concerned. As for the inclusion of Saiwan into the country park, what is the problem? The land wasn't in the country park, but because of the June 2010 incident, there was potential danger identified with regard to these enclaves. And we still have fresh memories about it. The mainstream opinion of the community called for enhanced supervision of these places, either by CPO or by the DPAs. And Saiwan is suitable to be included into the CPB rather than be put under the OZP. And the inclusion will make improvement. And this part can be considered as the country park. As for that will be good for the hikers. Why you don't use OZP? You just say that it will enhance management, but have you considered the land use and also the restrictions?
Indeed, Chairman, we consider that. We consider that on a case-by-case basis. It's not just about Saiwan. Well, in particular, in the case of Saiwan, we specifically consider that, and I'll ask the AFCD to supplement on the technical details. In terms of the aesthetic value and the recreation value, is very high. And also, if you look at the surrounding environment, and if you look at the picture, in fact, it's very scenic. We have the mountains and the waters and so on. Well, there are several important considerations for inclusion in a country park. Number 1, the conservation value. Number 2, the aesthetic value. And number 3 is the recreational value. And Saiwan, in terms of aesthetic and recreational value, is very high. And fourthly, well, that site, whether or not it's compatible with the other parts of the country park. And if you look at the country park, or if you've been there, you know that it's highly compatible. That's why the conclusion of the authority is that it's highly appropriate to designate it as part of a country park. And for the OCP, it's not entirely appropriate because basically it's part of the country park, and therefore the OCP would not be able to achieve the desired objective. In terms of flexibility, all right, after inclusion in a country park, there will still be flexibility because, as I said, for existing landowners and villagers, they can continue to apply for the building of village houses, and there is an explanatory note, and we will be processing the applications in accordance with the explanatory note. and the department can also supplement on the technical details. Yes, I'd just like to add a point. The reason why we are of a view that it's appropriate to designate it as a part of a country park, as Mr. Au explained, because of the aesthetic value and also the recreation value, because that site has a very high value, and we believe that it should be included in the country park. It's more appropriate to designate it as part of the country park, because after the designation, we'll be able to engage in more active management of the place. For example, we can also install some visitor facilities so that it can become more compatible with the rest of the Sai Kung Country Park. And also in terms of improvement to the environment, we will also be able to do more after its designation, because we can also adopt the same approach as running a country park in managing this place. For example, keeping the place clean and also arranging for refuse collection, and also if some facilities can be improved, for example for the hiking trail, and also whether or not it can also be converted into a campsite. So these are the measures that can be taken to better manage the place and also to increase the facilities for the visitors, so that on the whole, when the public want to use this place, they'll be able to benefit from the facilities. And of course, we will also be able to create a better environment for the local villagers, so that they can also benefit too. For example, if there are more visitors, and if it's turned into a campsite, for example, then there will be more people flow. And when they run some businesses, for example, running refreshment kiosks and so on, that would also help. So after considering the case in detail, we believe that designating it as part of a country park would be more appropriate than running it or managing it through the OCP or planning procedures. I stand to be convinced. Why is it better to designate it as a country park than zoning it under the OCP? Alright, originally there are no such facilities available. Why do they have to have such recreational facilities there? Without such facilities, maybe it's even more natural, because it's just a natural village. So it doesn't necessarily mean that if the guard railings are built by the administration and the floor tiles are provided by the administration, it will be good. Of course, as part of a country park, you'll be cleansing the place as if it's part of a country park. And then where there are people, there will always be hawkers or vendors selling soft drinks and so on. So I don't think you need to put your hand in. So what's the downside of doing it under the OCP procedure? And why is it that designating it as a country park will be somewhat better? So you have not explained. You just take it away and you're saying that, all right, this is a beautiful woman and therefore I'll have to marry her.
Well,
as I just explained the justifications, and let me repeat them. Well, the OCP and also designating country park, I think an important difference is the management, and the AFCD will be able to play a more active role. But then once it's shown under the OCP, well, basically there will be no management at all, because it's not a part of the country park. And designating it a country park, then we'll be able to manage it in accordance with the objectives of managing country parks, and therefore it's different from an OCP, where it's just about zoning of different pieces of land. Yes, Mr. James Tian, in paragraph 7 of your paper, you said that on the 7th of February 2013, there were 3 sessions held to listen to the objections, and the CMPB unanimously rejected all objections to the 2 draft maps. Can you tell us more about this? So apparently, you just rejected all the objections. Well, I suppose you have full justifications for that, instead of the authority just dictating that this be done. So can you tell us more about the background to this? Because I'm not very familiar with the background to this. All right, if small houses are no problems, then who else would be objecting? And why have you unanimously rejected all the objections? All right, because of the time limit, time is running out, so please be brief in your reply. And afterwards, I'd like you to give us all the details in writing, because Mr. James Tian, Mr. Tian Hangpan asked a number of questions. Please set out those details in a paper for us. Yes, Madam Chair, in Annex B, we have set out all the objections raised by the objectors. Well, basically there are 9 categories. So can you tell us the most important part of that? Well, they are mostly concerned about the private interests and also the developments that could follow. Why are they not designated or zoned under the old CP? And would that be compensation? There had not been adequate consultation, etc., etc. So those were the main comments. We have responded to that, and in Annex B, we have also set that out in detail. Well, basically, we are not trying to amend or change the ownership. So the nature of the land will not be changed. It's still private land, but then they will have to get the authorities' approval if they want to change the use or use it for certain purposes. The reason why it's not included or zoned under the OCP, that's because it's not appropriate. And in terms of consultation, we have consulted the local district council, we have listened to the villagers' views and so on. And therefore, the board was of a view that it had already responded to most of the comments, and for the concerns in relation to small houses, it's been explained that there would be this explanatory note on how cases or applications would be processed, and we believe that that would also help address the concerns raised by the objectors. And we believe that after the deliberation and after listening to the objections, it's appropriate to designate it all the 3 areas as part of the country park, and it was therefore decided unanimously to reject the objections. All right, Mr. Loy Kwok would like to speak for the first time. So please try to answer the questions as far as possible, and if you're not able to cover everything, then please do give us something in writing, and then we'll have to sort out the meeting schedule for the next few meetings. Yes, Dr. Low. Sorry, I was late because of a clash with other meetings. So, well, let me know if if my question has already been asked. Well, as some of my colleagues do, we are very concerned about the designation of the country parks, in particular in Saiwan village. The villagers' livelihood might be affected. So should we do it by way of an OCP, or should we do it by designating it as part of a country park? Well, from what I gathered just now, I haven't been able to get a satisfactory answer. Because even if you look at the written reply that you've given, well, apparently, if it's under the AFCD, everything will be fine. So I've had some years' experience in the TPB. Is somewhat different. If that's the case, then there is no need for us to go for an OCP at all, because with an OCP, you'll be able to designate the use in every part of the land. I think managing, if you're saying that is worse off when compared to AFCD's management, then why don't you just scrap the system altogether, and then everything or every piece of land will be under the AFCD. And if you look at the objectors' views, they said that their livelihood would be affected if you just build this reservoir and so on. So can that be ignored altogether? And they're also concerned about the support facilities, including roads, conservation, and so on. So these are very practical and specific requests. And you said that so long as it's under the AFCD, everything will be fine. You'll be arranging for refuse collection, and you'll be improving country roads or village roads and so on. I think this is really incredible. So, Madam Chair, yes, I've asked the question, but then I'm afraid they would just be repeating the same answers. So they might not be able to address the concerns, and that would not be helpful to our following up on the matter. So can they be more specific in responding to the questions that we asked? I've heard some questions and answers just now. And I'm afraid my concerns are still here. They have not been able to give us any convincing answers. All right. Just now, another member asked why they had not resorted to this OCP approach. They said that if it's under country parks, then the AFCD would be able to adopt a more active role. But then Dr. Lo Wai Kwok is asking, why can't it be done under an OCP? Okay. So administration, please prepare your reply. All right, sorry, only 3 minutes to go, Mr. Lo, and therefore we'll have to deal with our meeting schedule. Well, on meeting with deputations, I'm afraid that's a very essential part, and the Sai Kung District Council is also staunchly against it, and therefore, according to our established practice, we will have to invite the deputations to come, and Hang Yi-kok has already indicated that is against it. And of course, this will also involve many green groups and also landowners and so on. I'm sure they would also like to talk to us. Originally, we were only given this, that is the 6th of November. And for the background questions that have been asked by members just now, it shows that when we invite the deputations to speak, I'm afraid there would be many who would like to come. And therefore, I'd like to consult you. All right, how about 4:30 on the 5th of November? If there are many deputations who would like to come, then we can also extend it. We can last until, say, 7. And then as for the meeting or the time slot on November the 6th, well, after completing the hearing on Tuesday, then on Wednesday, we can ask questions. I hope to complete the scrutiny as quickly as possible, because this is by way of negative betting. We don't have a lot of time to go, and therefore please mark that down on the 5th of November, 4:30 p.m., and then on the 6th of November, 9 to 10:45 in the morning, and then on the 2nd of November is a Tuesday from 9 o'clock in the morning. So these 3 time slots first. November the 12th, Tuesday, 9 a.m. And we will have to report to the House on the 22nd anyway, even after the extension of the scrutiny period. All right, thank you.